Hello, and welcome everyone to Season 3, Episode 7 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Tarunima Vijra. I'm part of the ARBinBRIEF team and practice international arbitration at Artero and Vandenberg in Brussels. I have the pleasure of moderating today's episode on how to pose questions to witnesses as an arbitrator, featuring Christine Artero, an independent arbitrator with the Arbitration Chambers and Fountain Court Chambers, who's based in Singapore, and Manini Brar, arbitrator and counsel with Arbitration Chambers, who's based in Delhi. Most arbitration practitioners would agree that arbitrators have the right, and perhaps also a duty, to pose questions to witnesses presented in the arbitration. However, an improper or inopportune style of witness questioning by the arbitrator could potentially put the award at risk. We will explore with Christine and Manini today the arbitrator's precise role in witness questioning and the legal and practical considerations that one must bear in mind when posing questions to witnesses as an arbitrator. Today's discussion will be focused on the questioning of fact witnesses by an arbitrator. So jumping straight into it now, Manini, my first question is for you. Could you start us off by explaining how is witness examination generally conducted in an arbitration proceeding?
Thank you, Tarunima, and thank you, ARBinBRIEF, and all the sponsors for having me. On the process that is followed in the cross-examination, there are three distinct phases. One is the examination in chief, which is the primary statement that the witness gives, either on affidavit or otherwise. Then there is a cross-examination by the opposing counsel and a re-examination regarding any further questions that the witness's own counsel may want to ask. And the aim of the entire process is to find loopholes in the evidence-giving party's case or fortify the case of the party asking the questions. The arbitrator is in control of this whole process, which is effectively bound by time, in that both sides are usually given an equal amount of time to conclude their evidence. And the arbitrator can ask questions as he goes along and intervene at appropriate times.
Thank you, Manini. That sets the stage very well for my next question, which is to you, Christine. What is your view on who bears the primary responsibility of questioning witnesses in an arbitration? Would it be counsel or would it be the arbitrator?
Thank you, Tarunima, and thank you for having me. So your question is about who bears the responsibility, but I think you were right in the introduction to point out that to start with, the arbitrator has a right to ask questions, and I think that's being made clear by the IBA in their rules on taking evidence, rule, I think it is 84G, and it says that the arbitrator, the tribunal, may ask questions to witnesses at any time. This right can become a duty, and it will be a duty for the arbitrator in some instances. Say, if a witness misunderstands a question, you don't want that to go the wrong way. If a witness, even, taking an extreme case, and a witness may need some kind of protection from the tribunal if counsel asks misleading questions, and then it would become a primary responsibility or a duty for the tribunal to take the lead and to reformulate questions. Now, whose responsibility is it? In my mind, it is a shared responsibility, shared between counsel and the tribunal, the arbitrators, but you have to bear in mind that the purpose of questioning will be entirely different, obviously, and the tribunal will ask questions to ensure a full understanding of the case, of what happened, and to ask questions to be able to make an informed decision, while counsel obviously take one-sided view approach and will try to prove their case through questioning. Now, this responsibility or duty may be exercised differently depending who you are as an arbitrator, what's your background, and here comes, differences like common law and civil law background. But then when I was really thinking about it, and in my own experience sitting with different arbitrators from totally different backgrounds, I'm not sure the difference arises really from civil law common law background, but I think it's mostly from the personality of the arbitrators. And some like to ask a lot of questions and some like to listen and ask few. So yeah, that's.
Yeah, thank you, Christine. Let's move on now to the crux of our topic. And my next question is for you, Manini. When questioning a witness, are there particular considerations that the arbitrator should bear in mind? For instance, in terms of timing of the question, formulation, or level of intervention in the examination?
Yes, taking from what Christine already said, the aim is to get to the nub of the matter on facts, but not to lose the appearance of impartiality. And then that's where I think what Christine said about backgrounds really has relevance, because in India, the arbitration scene is so varied. You have the small domestic arbitrations, which are around small value claims, where you might have a district judge or a practicing lawyer sitting, and they follow court practice. Court practice in India is that the registrar can reformulate the question that is asked by the opposing counsel and can even dictate the question that goes into the transcript of the cross-examination. So the intervention is quite significant. And then you have much bigger arbitrations which are being administered by the SIAC or the ICC, where the tribunal takes a step back and doesn't really intervene as much or at all. Typically, what I do is I don't like to intervene with independent questions as we go along. If I absolutely have a question, I'll probably put it to the end of the cross-examination. But I do sometimes ask follow-on questions where I think that the witness is being evasive and the answer is important to get to the nub of the matter. I also intervene in places to instruct the witness so that I'm sure that he's fully understood the question when he's answering, whether it is on linguistic grounds or it is with respect to leading questions. So these are the few pointers that I follow.
Thanks, Manini. Christine, same question for you. Do you wish to add anything regarding the considerations that an arbitrator should have in mind when questioning witnesses? Additionally, could you also share your insights on what could amount to inappropriate questioning by an arbitrator?
So, okay, to add a couple of points maybe on what Manini said, I think one thing to keep in mind when you ask questions, it's nice to speak about it between, among the arbitrators, and to ensure that you've got quite a balanced volume of questions from both sides. It wouldn't look too good to have all the questions only from one side, and especially if all those questions come from the arbitrator that was appointed by the other side. And then I think one other thing to think about is whether the role will be different if you sit as presiding arbitrator or as co-arbitrator. In my view, it's not really different. And it will, the number of questions I would ask would just depend on the number of questions I have for that witness and not on my role. But again, I think it will depend on the dynamics of the tribunal. I've had a case, for instance, where my two co-arbitrators were very silent. So I was asking most, if not all, of the questions. And then I had another case where, again, I was presiding, but my co-arbitrators were extremely involved and very enthusiastic. And it was just natural that during the hearing, everybody was asking questions, and it didn't matter who was who and who was sitting in what capacity. And so long as the questions that need to be asked are being asked and answered, there is no issue as to who is asking them, I think. So those are considerations. And now about your question of what is to be avoided, what would be improper. I think any disrespectful, obviously, questions or using a tone that's unnecessary and disrespectful or aggressive. Unnecessary questions, irrelevant questions, that would be just a waste of time for everybody. Raising new issues, because I think at the end of the day, we are limited by the issues raised by the parties, and it's not for us to conduct our own investigation beyond those issues, unless we need them to decide the case, but then it's something we should have raised before. And obviously no biased question, but that's regarding biased question, something we discussed with Manini before is what do we need as arbitrator to ask only questions that are absolutely neutral and impartial? My view is if I see a weak point, a weakness in a party's case, I will question that party on that point. And it will show that I'm not convinced about what they say, but I think it's the right thing to do, in the sense that it gives that party an opportunity to explain and to address that weakness. And perhaps I've missed something, perhaps I may have misunderstood or missed a point, and then it is an opportunity, it is giving an opportunity to that party to address that issue. Likewise, an extensive or more vigorous questioning by the tribunal may not be sign of a biased tribunal. It may just be that we need to go to get to the bottom of that issue. The witness may be quite reluctant or evasive or not responding. So we may, pursue that line of questioning, but that's not showing bias. It's getting to the point.
Thank you. Thanks, Christine and Manini. I would like to change tack slightly now and touch upon the situation in default proceedings with both of you. And Christine, I'll start with you. In default proceedings, as there's no cross-examination by the opposing side, how do you perceive the arbitrator's role in witness examination? Would the arbitrator take over cross-examination, perhaps to the same extent that opposing counsel might have done?
So I don't think you can really compare the role of the arbitrator to, or the questioning of the arbitrator to cross-examination, but of course, the role of the arbitrator will be quite different when there is a non-participating respondent, for instance, and the tribunal will really need differently, in a different way than it would with a participating and represented party. It would need to apply its mind to the facts of the case, question the other side's case in a more thorough, even more thorough way, and think about all the issues that the respondent would have raised. And it cannot leave any stone unturned. Basically, it would have a stronger duty to test the claimant's case. It would be more proactive, would ask more questions. So now, for witnesses, I guess, so if the claimant would adduce a witness, would you have to call him in any event? I'm not sure. I mean, you've got some witness statements that are pretty empty with no substance in them. So I don't think because the respondent is not participating, the tribunal would have absolutely a duty to call that witness and to question them if they don't have questions for that witness. So you would call the witness if you have questions for them. Would my questions be different if the respondent was represented or not? Again, I'm not sure. Well, I'm sure I would test the claimant's case much more, but the substance of the claimant's case much more than the witness themselves. I'm not going to try to push them like counsel would do in cross-examination, but I would ask all the questions I have. But like I did in a recent case where the respondent barely appeared, I sent a list of questions to both parties before the hearing to show where the weaknesses on both sides and to prepare the hearing, and we addressed all those questions during the hearing. But that's testing the substance of the other party's case, not the witness really themselves. So that's my view on non-participating respondents.
Thank you, Christine. Manini, same question for you. Do you wish to add anything on how an arbitrator's role in questioning witnesses might differ in default proceedings?
No, largely I agree with everything that Christine has said. There also was a famous case, the Delarue case of 2014 in the UK, where in one such situation, the court agreed with the approach adopted by the tribunal, where the counsel took the tribunal through the witness's statement and largely through the examination in chief. And then the tribunal asked one or two questions on facts. And I think the underlying tonality there was that the evidence should not be accepted without applying a critical mind. I think that is what is also reflected in the CIR guidelines on party non-participation. And the situation is same in India. In India, in the Arbitration Act, we have a provision which says that if a party is not participating, the tribunal may proceed to make an award on merits based on the evidence before it. And then there is a separate duty on the tribunal to evaluate the admissibility, relevance, weight, materiality of the evidence. So I think the common strain is that the evidence should not be accepted uncritically, and that the tribunal should at least be seen as examining the evidence on these parameters.
Thank you. Thanks, Manini. Well, thank you very much, Christine and Manini, for this incredibly insightful discussion. We would like to thank our partner organizations, 𝗔𝗥𝗕𝗙 and the Lagos Chamber of Commerce International Arbitration Center, for their invaluable support for making Season 3 possible. We are also truly grateful to the many organizations that support the marketing of our series around the world. For those of you who are watching us on YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback. You can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.